right, then this is 21AC-CC 00186, Doyle and others versus Jennifer Tidball. For the plaintiffs, I've got Chuck Hatfield, Joel Ferber, and Ms. Cossette, and Lowell Pearson. For the state, I got John Sauer and Jesus Osete. All right, matter comes on today for trial. We have a stipulated record, which I've had a chance to look a little bit at. Any preliminary matters for the plaintiffs?
No, Judge, for the sake of the record, I move that you accept the stipulations, which includes Exhibits 1 through 35.
No objection, we agree.
All right. Before we start here, before we proceed past this point, I am obligated to remind everybody that pursuant to Supreme Court Operating Rule 16, there is no recording or otherwise broadcasting, texting, blogging, whatever it is, from the courtroom during these proceedings. Pool camera from KRCG, pool photographer for the News Tribune, and those members of the media, they should make available to you what they've got here. But as far as sitting in the back with your iPhone, that you cannot do. So, other than that, are you ready, Mr. Hatfield?
The plaintiffs are ready, Your Honor.
Stay ready.
We are, Your Honor.
Thank you, Mr. Hatfield.
Thank you, Your Honor. As you indicated, the parties have stipulated to the facts and the exhibits, and I just have to say that's the way it should work. We appreciate Mr. Sauer and Mr. Osete cooperating to get this case presented, so Your Honor doesn't have to deal with, I believe, any procedural issues here. We're ready to proceed straight to the issues. And on that point, Your Honor, you've seen some briefing already. Plaintiff's case is fairly simple. We rely on the plain language of the Missouri Constitution, the plain language of certain appropriations bills, which we brought to your attention, and the 2020 Missouri Supreme Court case of Planned Parenthood versus this same set of defendants, the Department of Social Services. So, as Your Honor knows, sometimes when we're in big cases like this, if you will, I say to you, there is no precedent on which for you to rely. But here there is. The case decided a year ago this month was not just helpful. It specifically addressed appropriation language that the state claimed affected the ability of the department to make payments for Medicaid. That case specifically addressed that issue, and I'm going to tell you a little bit about that as we go. But as Your Honor knows, Medicaid is a program that has certain individuals who are eligible, and then there are certain services they may receive. And so, for example, we've got a very short little PowerPoint just to draw attention to some things. Under 208.151, this is not the whole thing. It's an extremely long statute. Your Honor probably already knows that that statute specifies who's eligible to participate in Medicaid. So those who receive aid to families with dependent children, those who receive blind pension benefits, those who are eligible for old age assistance. That's been on the books, 208.151, in terms of Medicaid eligibility ever since I can remember. That set of people who are eligible for Medicaid was, as you know, recently expanded by an amendment to the Missouri Constitution. And Missouri Constitution Article 4, Section 36C is here on the screen, and Your Honor has it in the briefing. And it talks about who is now eligible. I'm going to talk to you about much of that, but important to get us oriented here is the very last phrase. After the citation to the CFR there, it says, these individuals specified above shall be eligible for Medicaid assistance under MoHealthNet and shall receive coverage for the health benefits service package. Now, the service package is defined elsewhere in statutes in Chapter 208.152, or Section 208.152. There are, when you read the Planned Parenthood case, you'll see, for example, they talk a lot about that particular statute. It's a long list of the various services that eligible individuals may receive. Judge, if the legislature wants to change the eligibility requirements for Medicaid, they can do it. They've got a couple of ways to do it. They can amend these statutes that we looked at, 208, or in the case of the Constitution, they could propose a constitutional amendment to change those eligibility requirements that are now ingrained in the Constitution. And as Your Honor knows, not long ago, there was another constitutional amendment people sometimes call Clean Missouri. The legislature wasn't particularly enamored with that idea. They proposed a constitutional amendment. The people adopted that and changed the law. But those are the two ways that the legislature can change eligibility. They've done it on many occasions. So, for example, back in 2005, during the Blunt administration, the legislature made a decision to reduce certain eligibility for durable medical equipment. And they did that by changing some of the provisions of Section 208.152. They also, later in 2007, came up with the Ticket to Work program, which changes eligibility for Medicaid. And it did that by making a statutory change about eligibility, who was eligible and for what. So, as Your Honor has read the briefs, the state has laid upon the metaphor for this case that the legislature does not hide elephants in mouse holes. The elephant here was a constitutional change. It was not hidden in a mouse hole. It was done by the people. It's in the Constitution, and it cannot be changed except by statutes or by an amendment. It cannot be done in an appropriations bill. So there are two cases. The Planned Parenthood case is the main case, but another case that is a little instructive for Your Honor is the McNeil-Terry case, which we cited in 2000. That case was in 2004. There, the department tried to curtail dental benefits. And the Court of Appeals said that even though the dental benefits were not funded by the legislature, that in fact the department had to provide those benefits. There they talked about the fact that the dental benefits provision does not say that it's subject to appropriation. And so they found that the state was required to continue to provide the dental benefits even though the legislature had not funded it. Now, that's kind of an extreme case in a lot of ways, but we don't have that problem here because we have an appropriation, as we've talked about. So, briefly on Planned Parenthood. Planned Parenthood, I think, really controls here, and I don't think the court has much work to do to understand what the law is. Now, the issue in Planned Parenthood, Judge, is that the legislature in an appropriations bill said no family planning funds may be used for those who provide abortions or those who are affiliated with those who provide abortions, meaning Planned Parenthood. That was in the appropriations language. Yet, there was a statute in 208-152 that said there shall be family planning services available to those who are on Medicaid. And the Supreme Court found that that language in the appropriations bill that limited who could be funded was unconstitutional. They said MoHealthNet, the defendants here, is bound by the general law, in that case, the statutes, defining what those, I said it was okay to have a camera there, now I can't read it. But I have my, defining what those services are and which providers are entitled to payment. Any attempt to use an appropriations bill to amend such general laws necessarily runs afoul of the multiple subject prohibition in Article 3, Section 23 of the Missouri Constitution. And I think Your Honor knows, but the issue there, right, is that the Constitution prohibits multiple subjects in a bill, and then it says, except for appropriations bills, which shall contain the amount and the purpose for an appropriation. And the Supreme Court interpreted our Constitution to say that all that may be in an appropriation bill is an amount and a purpose. And if there's an attempt to amend another statute by, for example, saying family planning money but not for these individuals or for these particular providers, if that's done, that is doing two things, if you will, and that is outside of the limitations on appropriations bill, which are the purposes and the amounts. They also said in Planned Parenthood that if there's a direct conflict, Section 11.800, which was the language that said the appropriation shall not be used for abortion providers, is invalid because Article 3, Section 23 of the Missouri Constitution prohibits using an appropriations bill to amend substantive legislation. That's basically the state's argument, that the appropriations bill amended the Constitution and denies our clients the eligibility that the Constitution guarantees to them. So the analysis goes like this for this case. The first part is eligibility. That's determined by looking at the substantive law in the Constitution. The second part has to do with the appropriation. And unlike the interveners that Your Honor heard from, the plaintiffs here, we acknowledge that under the Missouri Constitution, no expenditures may be made except subject to an appropriation. So you have to have some authority to pay for Medicaid. So the question for the court is whether the substantive law makes our plaintiffs eligible and whether there's an appropriation to cover the services they say they're entitled to. Eligibility, again, constitutional provision. This is the longer version, but Your Honor can read all of that. There's nothing ambiguous about it. It specifically says shall be eligible. It specifically says shall receive services. The parties have essentially stipulated on eligibility. Paragraphs 1 through 16 of the stipulations walk through the income requirement and what these plaintiffs meet, their status with dependents, et cetera. And I think pretty clearly establishes that they would be eligible on July 1 under the provisions of the Constitution. But as you will see in paragraph 106 of the stipulations, the parties have agreed that, quote, if the plaintiffs, our clients, attempt to enroll in the MoHealthNet program, the Family Support Division will not enroll them because their eligibility for the MoHealthNet program arises solely under Amendment 2. And even though the no longer quoting, even though the Constitution says, quote, shall receive coverage for the health benefits, end quote, paragraph 107 of the stipulation stipulates that, quote, defendants will deny MoHealthNet benefits to individuals whose eligibility for the MoHealthNet program arises solely under Amendment 2. Why? Well, it's pretty clear from the briefing. The state's position is that there is no appropriation to pay for these services to these folks who are eligible. But there is. And by the plain language of the appropriations, you can see that. In the record are certain appropriations bills. We have stipulated, I messed you up. We have stipulated that MoHealthNet is the title for the Missouri Medicaid program. So when we say MoHealthNet, of course, that's what we mean. We have stipulated that the MoHealthNet program provides medical assistance to eligible Missouri residents. So what you have in the record then is the House bills, and you have all of them. We've just selected some for purposes of this argument. Section 11.700 appropriates to the Department of Social Services for the MoHealthNet division, provided that no more than 3% flexibility is allowed. For what? So when you walk through the language there, what you see is that the bill has appropriated for, in this instance, pharmaceutical payments. One of the things our plaintiffs alleged in the petition they need is pharmaceutical coverage. Pharmaceutical payments under the MoHealthNet fee-for-service program, professional fees for pharmacists, for comprehensive chronic risk managed program, and you can read the rest, provided that flexibility between various appropriation amounts. When you drop down, you'll see that there's more than $1 billion that has been authorized and appropriated for the pharmaceutical program. Nothing in this appropriation to pay for pharmaceutical services talks about eligibility. And when Your Honor looks through the bill, you will see that the legislature never covers eligibility in the appropriations bills. That's not where it belongs, as Planned Parenthood says. The appropriations bills fund services. The eligibility is substantive and can't be done here. The other example that we put up is the physician services line. So here again, there is funding in the appropriations bill now for physician services and related services, including our plaintiffs have asthma, there's asthma-related services, diabetes, there's diabetes prevention, and I'm reading after diabetes prevention, and obesity-related services provided by chiropractic physicians and family planning services in what program? Under the Mo Health Net Fee-for-Service program. Again, no eligibility restriction, and you'll see that there's also language for various other services. There's one for managed care that the parties talked about. Very similar language. This money is there to pay for services, and it does not restrict it based on eligibility. So it's a plain language analysis, and the state argues that you should look outside of that plain language to somehow determine that, well, it doesn't really mean what it says. It doesn't really mean that those are appropriated. The state argues, now, among other things, the state argues that the Constitution did not appropriate this money, and so therefore the legislature has to make an affirmative appropriation. We argue they already did, and that's just the plain language analysis. But the Supreme Court addressed this exact same issue of the state's argument that there is no appropriation in the substantive law in the Planned Parenthood case. And here they said plainly, nothing in that case, the statutes, purports to appropriate money or require appropriation. It's beyond question, and we don't question it, that the General Assembly has discretion to decide. I've got to go back to my sheet here because I can't read over her head. Has discretion to decide appropriations on an annual or biannual basis, but these bedrock legal principles do not resolve the case. In the Planned Parenthood case, they said, the General Assembly chose to appropriate nearly $400 million for physician services, family planning. It's actually the same section we just looked at. This was one of thousands of difficult decisions that they made, and then the last sentence is important. Having made this decision, Mo Health Net is bound by general law defining what those services are and which providers are entitled to payments for delivering them. Once an appropriation is made for a service, as was done here, the General Assembly is bound by the general law and must comply with the Constitution, which allows eligibility. And when you read that case, you'll notice that the Supreme Court specifically talks about how appropriations bills fund services, and they talk about that all the time. That makes a lot of sense from a policy perspective. When we're talking about who's eligible, we look to the permanent substantive law that has to be amended by an act of the General Assembly in a single subject bill, have an opportunity for the governor to review and veto that if necessary. Appropriations change constantly. There's a new one every year. There can be different amounts depending on who's in the program, who's out of the program. As we've included in our 35 stipulated exhibits, the legislature is regularly required or finds it necessary to do supplemental appropriations because there isn't sufficient funding for what they thought would happen. The appropriations process necessarily goes up and down, and so the law that the Supreme Court articulates here is also very good public policy, and it makes sense that that's what the Constitution requires. So here the legislature has appropriated. I'm going to go back on you, Alex. What the state is asking you to do in their briefing is to insert some language into these appropriations bills. In 2019, the year before, or actually 2 years before we're arguing about here, the legislature did that. In the appropriations bill, they said, no funds shall be expended for the purpose of Medicaid expansion as outlined under the Affordable Care Act. That's not in this bill. They affirmatively took that out. Now, The state's brief suggests that they did it because of the Planned Parenthood case. That makes sense to me. This language was unconstitutional. And they cannot do implicitly what they could not do explicitly with this language. It's not there anymore, and it makes sense that it's not there, and it shouldn't be there. So you're going to hear from the state. You've seen their briefing. They don't explain why the plain language of these appropriations and the Constitution doesn't mean exactly what it says it does. Instead, they want to look at aids to construction. But, as Your Honor knows, we don't go to aids for construction if the language is clear. And we don't do any extra textual analysis unless there is ambiguity. The state's briefing tries to create ambiguity by telling you to look at information other than the plain language. They say, well, here's what it says, but we've got some newspaper articles that say something different. Or here's what it says, but it looks like maybe they didn't provide enough money to really do exactly what it says. And even when you engage in that exercise to go outside of the plain text, you'll see that that analysis isn't right and doesn't get them to the result. And I'm not going to go through all of it. I think in the state's reply brief, they start with 11 different items, and that's a useful list. I'll wait and see which ones are emphasized, and then I can talk to you about those. But just a couple that I wanted to mention to you. They talk about it's an absurd result that the legislature may have underfunded the program. Well, the legislature has underfunded the program and is apparently going to come into special session over the FRA. It is not absurd to realize that perhaps the legislature hasn't provided enough funding to do the things that are specified in the Medicaid program. It doesn't change the plain language of these appropriations. It happens all the time. Also, on these news articles, there's dispute even in the news articles about exactly what happened. In Exhibit 20, which is stipulated to, the majority leader of the Senate, Senator Rowden, has quotes in there that I won't recite for you that basically say what I'm telling you, which is that there is no funding of an expanded population. There is funding of services. These services are funded, and they must be provided to everyone that the Constitution authorizes to receive. So, Your Honor, I know there's a lot going on in this case. There's a lot of different implications to this case. I noticed that the state's reply brief begins by saying that the plaintiffs interpret the Constitution and the appropriations with blinders on, and that's true. We do have blinders on. A lot of times the statue of justice has a blindfold on. We're not supposed to consider all of the things you're getting ready to hear about. We're supposed to look at the plain language of these enactments that were enacted by the full body and make a determination as to whether our clients are eligible and whether there is, in fact, an appropriation to pay for the services. And when you do that analysis, I think you're going to see that there is. Your Honor should follow the Planned Parenthood decision of the Supreme Court and enter an order that these plaintiffs are entitled to enroll in the Medicaid program July 1, and they are entitled to the services that the law guarantees them. Thank you.
Thank you, Your Honor, and may it please the court, please let me know if you can't hear on the microphone. John Sauer, appearing on behalf of the state. Excuse me, Your Honor. Mr. Hatfield started his presentation by saying that the plaintiff's interpretation of these statutes is, quote, fairly simple. And I think that that's true. It's misleadingly simple because, as we said in the beginning of our reply brief, they want to put kind of tunnel vision, blinders on, when they look at this appropriation bill and not consider all the relevant information, not factual information, not extrinsic factual evidence of meaning, but legal evidence of meaning. And I like to emphasize the phrase that the Missouri Supreme Court used in the Fust against Attorney General opinion, which is the phrase of a reasonable reader. What would a reasonable reader who picked up one of these appropriation bills consider when they flipped through it and tried to read it and say, hey, are they funding Medicaid expansion or not funding Medicaid expansion in this particular appropriation bill? And I submit to the court there are at least 9 strictly textual indicators of meaning in these appropriation bills that all confirm that what's going on here is just funding the pre-expansion population, not funding services for the expansion population. And keep in mind that a reasonable reader is not an ignorant reader. A reasonable reader is not someone who doesn't understand what Medicaid is, who doesn't understand that there's federal and state matching that goes on in Medicaid for funds, who doesn't understand what the expansion population is. I like to think of the reasonable reader in this case as maybe a financial staffer at the Department of Social Services who hasn't been reading the papers for the last few months, who hasn't followed the legislative process, but is wondering, hey, we requested funding for Medicaid expansion, and they receive House Bill 11. And they look at it and they say, I wonder if we got the funding we asked for Medicaid expansion. And they start flipping through the bill. The natural place to start is actually page 8 of Mr. Hatfield's presentation. That's section 11.700. And if you turn to that page, it's page 8 of the PowerPoint, and it's also page 38 of the bill, which is exhibit 12. Section 11.700 appropriates funds for pharmaceutical payments, prescription drugs, essentially. There's a lot of money appropriated there, but if you eyeball that, there's $901 million of federal funds and $1.302 billion of total funds. So a reasonable reader who's informed about Medicaid understands something. They understand that the FMAP, the federal matching rate for federal and state funding of Medicaid for the pre-expansion population is this year 66.36%. That's set forth in the Federal Register every year. It changes a bit every year, but it's right around that 2/3, 1/3. Whereas the Medicaid, the expansion population has a very special and much elevated matching rate. That's 90-10. And if you look at this, your reasonable reader looking at this bill for the first time says, oh, look at this. 901 over 1.302 billion, that's right at 66%. It's actually, I think, a little north of 67%. So that's right near the 2/3 you'd expect to see for the non-expansion population. And it's literally nowhere near the 90-10 matching rate you'd expect to see for the expansion population. So right away, that's a big flag to the reasonable reader. They say, oh, look, doesn't look like we got the funding here, at least for pharmaceutical services, because they're appropriating it 2/3, 1/3. And that's what you do in old Medicaid without expansion, whereas I don't see any 90-10 breakdown here. And then the same reasonable reader can keep flipping through the bill and get to section 11.715, which plaintiffs also cite. And once again, you see a 67% matching rate for matching funds, right at what you'd expect to see for the non-expansion population. And I won't go through all the sections, but we discussed a couple of these in the opening brief, and I went through literally every section in the reply brief in these two appropriations bills, not just HB 11, but also HB 10 that has some services for Medicaid expansion, home health services for the needy that are administered by DHSS. And you go through every single one of those bills, you're looking at a federal state matching rate right in the zone of 67%. It's at 65.6 is the lowest it gets, 69.3 is the highest percent. It's exactly kind of what you'd expect to see, right in the zone for Medicaid without expansion. Whereas if you were looking for Medicaid with expansion, you'd be looking for 90-10, or maybe a hybrid of those two, and it just isn't there in the bill. So right off the bat, this reasonable reader is like looking at House Bill 11 and comes to the natural conclusions like, oh, looks like we did not get the money we requested for expansion, because they are doing what they always did, which is appropriating at the matching rate for non-expansion. And that's the first textual feature of these bills that a reasonable reader would understand what's going on here, is appropriation for the pre-expansion population. But there's a lot more. I point to a second one. And that is, if you actually, Mr. Hatfield said there's no reference to eligibility criteria in the appropriation bill, but that's not really true. If you go to section 11.760 of the bill, which I believe is at page 45 of Exhibit 11, sorry, page 46 of Exhibit 11, this is a major appropriation for managed care services for the appropriation population. And you go through the paragraph line item there on the top half of the page, which is lines 3 to 22, there's two explicit references to the pre-expansion population in a context that it's clear that they're not including the expansion population. So, for example, further provided, starting at line 9, further provided that Mo Health Net eligibles described in section 501A1D of Title V of the Social Security Act. That is the pre-expansion population, the aged, disabled, the needy, people with dependent children. It's not the expansion population. May voluntarily enroll in the managed care program. So this appropriation says, look, the pre-expansion population may voluntarily enroll in these managed care program that we're financing. But it doesn't say that the expansion population can't. And the very next clause kind of doubles down on this. It goes on to say, further provided that the department shall direct its contracted actuary to develop an aged, blinded, and disabled rate cell. Again, that's the pre-expansion population. There's no mention of a rate cell for the expansion population in administering these services. So once again, the reasonable reader looks at that and says, oh, that confirms what I already thought from looking at the breakdown rate, that what's going on in this bill is appropriating money for the pre-expansion population, not the expansion population. But there's more, because plaintiffs only made allegations about House Bill 11 in their petition. But really, to implement Medicaid expansion fully, you need 3 different appropriation bills. You need House Bill 11 for DSS, House Bill 10 for DHSS, but also you need House Bill 5, which is the appropriation for the Office of Administration. And why is that? Because there's administrative costs, information technology costs that are associated with radically expanding the population of people eligible for Medicaid. You can't just enroll 275,000 people in your existing computer architecture. And so a reasonable reader would understand that and say, I wonder if we got the appropriation for Medicaid expansion in House Bill 5. And if you pull out the House Bill 5 that the legislature passed, there is a generic appropriation for information technology services to DSS, as there is every year, and it's along with virtually every other state agency, essentially. But this is on page 8 of House Bill 5, which is Exhibit 3, lines 104 to 107. It says, here's information technology costs for the Department of Social Services. Personal service, $1.18 million. Expense and equipment, $3.18 million, $1.28 million. From General Revenue Fund, the total of $4.462 million. Not a penny of federal matching funds to implement the administrative costs of Medicaid, but those federal matching funds are available. If you're expanding your computer architecture to implement Medicaid expansion, the federal government is going to pay for most of that. If you actually look at House Bill 20 on page 2, you see an example of how this would be. A reasonable reader who understands Medicaid would expect this to be done. It would be a huge red flag to say, well, obviously they haven't given us the money we need to implement Medicaid expansion through its information technology costs because there's literally no federal matching at all. They're only giving us general revenue funds, but the federal matching funds are available, and there's no reason the legislature wouldn't give them to us if they were funding Medicaid expansion. So that's a third indicator that a reasonable reader who kind of understands the Medicaid program and is informed, looks at these bills and understands what's going on, is they're just funding pre-expansion Medicaid. And there's more. For example, there's a kind of established nomenclature that applies to the expansion population. For example, in the state plan amendments, the department uses the phrase adult expansion group. And then there's also the actual eligibility criteria that are spelled out in like 4 lines of Article 4, Section 36C. And a reasonable reader who's wondering, hey, are these appropriation bills appropriating money for the expansion population, might flip through there and say, well, is that phrase adult expansion group, or those eligibility criteria about being age 19 to 65 and a certain level of the federal poverty level and so forth, are those included in those bills? Nowhere. Plaintiffs haven't cited anywhere in any of these bills, House Bill 11, House Bill 10, or House Bill 5, that those eligibility criteria are ever referred to. So that's another indicator. It's like, it looks like what's going on here is we didn't get the money for the expansion population. A fifth argument in this, a reasonable reader would understand that the legislature doesn't just appropriate money in a vacuum. It responds to budget requests. And the governor and the department put forward a budget request every year for the expansion population. And what you see if you go through these line items, there's actually, I think, a helpful table in our trial brief about this that goes through the sections on which plaintiffs specifically rely on. And you look at those budget requests that the governor made and then what the legislature actually appropriated, it's closely tracking. It's not dollar for dollar exactly. It's very closely tracking what the governor was requesting. Whereas it's nowhere near what it would be if they were giving what the governor requested for non-expansion plus what the governor requested for expansion. They're matching the governor's budget requests for the non-expansion population again and again as you go through the line items. That's incredibly powerful evidence to a reasonable reader. Look, what's going on here is funding for the pre-expansion population. And if you take a step back and consider that point in the aggregate, I think you get to a sixth point, which is that if you look at, for example, the entire budget for Medicaid in House Bill 11, it's something like a total of $8.6 billion. There's almost $2 billion missing from the Medicaid budget if plaintiffs are correct. They underfunded. If plaintiffs are correct in that these appropriation bills are authorizing money to be spent both on pre-expansion and expansion, when what they've actually given is the amount of money that directly tracks what the governor asked for just pre-expansion, there's a radical underfunding of Medicaid that happened in this particular bill. Can the legislature underfund Medicaid? Perhaps has the authority to do that, but a reasonable reader wouldn't expect that. A reasonable reader who says, look at these numbers where you're directly matching up non-expansion is a rational inference from that to say, oh, look, they funded them both. They just underfunded them to the exact tune of the missing chunk that you'd expect for the expansion population. No, the natural inference is they gave just the money that was requested for the non-expansion population, and they didn't provide the money that was requested for the expansion population. So that's a sixth textual feature of these, where you don't have to go to extrinsic meaning, textual feature of these bills that a reasonable reader would read them and understand. They did not finance Medicaid expansion. They also, Mr. Hatfield actually relied on the prior recent appropriation bills for DSS and said, some of these had specific language in Part 2 of the bill that imposed a restriction on funding. But there's an even closer textual feature of those bills that a reasonable reader would be aware of. If you look at the services language in those bills that appropriates money for services in the specific line items like Section 11.700, 11.715, and so forth that they rely on here, you go to last year's bill for DSS and the year before that for DSS, and you look at those, they're appropriating money in exactly the same language, virtually exactly the same language. We cited the various exhibits on this in the trial brief. But the big picture is the legislature used virtually the same language to appropriate money for Medicaid services in 2019 and in 2020 as it did in 2021. But everyone knows they didn't fund Medicaid expansion in 2019 and 2020, so it'd be very unreasonable to look at that same language and those same line items and say it's doing something radically different now. And in fact, a reasonable reader would say, hey, and there's a legal principle of interpretation for this. It's interpreting those bills in peri materia. They're bills that are addressing exactly the same topic in consecutive years. And on plaintiff's argument, the line items mean exactly the opposite, or not exactly the opposite, but something radically different than what they meant in 2020 and 2019. Again, that's just not reasonable interpretation. There's also a restrictive clause in the beginning, right in the preamble, on page 1 of House Bill 11, where it says that the money appropriated here shall be expended only for the purpose of funding each department, division, agency, fund transfer, and program described herein for the item or items stated, and for no other purpose whatsoever. And so a reasonable reader looks at that and says, I know what the legislature's saying here. They're telling the department it can't do exactly what plaintiffs are saying it should do here, which is kind of leaf through it and make some negative inference that radically expands their appropriation authority. They're saying, no, this is a principle of strict construction when you go through this. Don't try trying to expand the purposes that are recited in here, and that's yet another indication that their interpretation is not a rational interpretation. It's not a plausible interpretation. Mr. Hatfield talked about the maxim of elephants and mouse holes. I don't think you need to rely on that phrase, although the Missouri Supreme Court did in the recent RMA decision. But just think about what a reasonable reader would say. Expanding Medicaid is a huge deal. It's a policy decision of enormous import. If the legislature is going to decide to fund or not fund Medicaid, a reasonable person would say, you'd expect them to be clear about that. That'd be a decision to be made with bells and whistles, one way or the other. And what they're arguing is that there were no bells and whistles here. In fact, there's this silent, indirect inference from the silence in the appropriation line items. Because there were 14 or however many sections we're talking about here, it's at least 9 or 10 appropriation sections. Because there weren't 9 different explicit statements of limitation in each of those appropriation line items, therefore the whole Medicaid expansion is funded. Again, that's not what a reasonable reader expects. A reasonable reader expects a decision of this tremendous importance to be made in clear and express terms. And that's what the elephants and mouse holes canon teaches us, and that's the instruction from the Missouri Supreme Court, and the court should follow that in this case too. So by my count, I've gone through 9 indicators of statutory meaning in the appropriation bills, none of which rely on extrinsic evidence. Mr. Hatfield said, Mr. Sauer is going to come up and he's going to try and pivot straight to extrinsic evidence. Not at all. You just got to go burrow through these texts through the lens of an informed observer who understands Medicaid law, and it's perfectly clear that what's going on here is appropriation just for pre-expansion population, not the expansion population. But if you go even farther, suppose the court decides, well, you know what, I think it's ambiguous. I'm not sure what they were getting at here. If the court determines that this is ambiguous, then the court can rely on extrinsic evidence of meaning. And here, there's several important things here. One is the legislative debates, because there's a whole bunch of this about them in the stipulated facts. But they paint a very clear picture. There was an enormous legislative debate about this issue in the most recent General Assembly. It was raised, the issue of whether to fund expansion was raised again and again and again. There's a whole series of intense debates and close votes. It was considered through the vehicle of 4 different bills, House Bills 5, 10, 11, and House Bill 20. At one point, they peeled off all of the legislative package that would have funded expansion and submitted it as a separate bill. It failed. There were multiple attempts to amend 10 and 11 and 5 to include Medicaid expansion. In each case, each one of those amendments was defeated. There were floor votes in both the House and the Senate on this very issue in this same legislative session. And those floor votes did not enact Medicaid expansion. At the conclusion of this process, all the reasonable participants in the process, the governor, legislators who supported expansion, legislators who opposed expansion, all thought they hadn't funded Medicaid expansion. So that's actually a plain meaning argument I would submit to Your Honor. because the plaintiffs have to argue that what this really means to an ordinary, its objective meaning to a reasonable reader, to an ordinary person, its plain and ordinary meaning, is the opposite of what every informed observer in the legislative process thought it meant. That is absurd, it's illogical, and it is not a valid interpretation. So for all those reasons, I would submit to the court that the question of statutory interpretation is actually pretty clear. If you actually go through these bills in detail, it's just clear the legislature was not funding the expansion population, for better or for worse. These are appropriation bills that fund the pre-expansion population. So once you get there as a question of statutory interpretation, then it does present the question, which I'm not clear now for what Mr. Hatfield is arguing, but I understood for the first 6 pages of their reply brief that they are arguing that if these bills didn't fund expansion, that is unconstitutional. In other words, their argument, as I understand it, and I think it's very clear based on the reliance on Planned Parenthood against DSS, is the legislature could not constitutionally have passed an appropriation bill that gives money for the expansion population, but not for, gives money for the pre-expansion population, but does not give money for the expansion population. They say that violates the single subject rule. The legislature is really changing the eligibility criteria for Medicaid by doing that, by funding only some of the eligible population and not the others. And they say that's unconstitutional under Planned Parenthood against Department of Social Services. That's wrong for 2 reasons. And I want to start with the actual test in the Planned Parenthood case, which is, again, quoted in Mr. Hatfield's presentation. It's direct conflict. It is only an appropriation, it's only according to Planned Parenthood against DSS, the standard is it's a substantive amendment to a pre-existing statute, substantive statute, in appropriation bill is impermissible if the 2 provisions are, quote, in direct conflict. So if there is a direct conflict, a kind of logical inconsistency between these appropriations bills and their refusal to fund the expansion population, and on the one hand, and Article 4, Section 36C, that is what triggers a problem under Planned Parenthood against DSS. But there is no logical inconsistency because funding and eligibility are not the same thing. In other words, to get Medicaid services is really 2 logical steps. You have to be eligible under the law, and then the legislature has to give money to pay for the services. And that's why every year there are substantive statutes like 208.152 that Mr. Hatfield talked about that said here are the services, 208.151 that says here's the eligible populations. But if all we had was those statutes every year, no one would get any Medicaid services because there has to be that separate step of appropriation. So for the legislature to refuse to fund what are admittedly eligible people under Article 4, Section 36C is not a direct conflict. And you don't have to take my word for this because Mr. Hatfield and Mr. Pearson argued this to the Court of Appeals in Katie against Ashcroft. Here's page 35 of their brief. They said eligibility, the subject of the initiative, that's Amendment 2, is distinct from funding. Who is eligible does not tie precisely to costs or appropriations. It was critical. They had to make that argument that funding and eligibility are different things because otherwise Amendment 2 couldn't go on the ballot. As the court is aware, Article 3, Section 51 states that the initiative shall not be used for the appropriation of money other than new revenues created and provided for thereby. So if Amendment 2 requires the legislature to engage in an act of funding, active appropriation to fund the expansion population, either directly or in the words of the Missouri Supreme Court in Chastain, by practical necessity, it was never validly enacted in the first place. And that's why their argument that the legislature is obligated to this is essentially self-defeating. Because if that's true, and that the legislature was constitutionally obligated under the single subject requirement to fund Medicaid expansion through House Bill 11 this year, then Article 3, Section 51 and Article 4, Section 36C, enacted by Amendment 2, are in what the Court of Appeals called in Katie against Ashcroft, irreconcilable conflict. And because Article 3, Section 51 is a procedural mechanism to get in the Constitution in the first place, that means that Amendment 2 was never validly enacted, and someone can bring a post-enactment challenge to get it stricken from the Constitution. But that's not the route the court should go, because the state argues, and that's actually exactly what Mr. Hatfield and Mr. Pearson argued in Katie against Ashcroft, that there's a perfectly consistent interpretation here. And in fact, it's the interpretation that the Court of Appeals itself adopted in Katie against Ashcroft when it ruled that this could go on the ballot, which was the position advocated by the attorneys for the plaintiffs here and advocated by Mr. Lewis on behalf of the state. In Katie against Ashcroft, the Court of Appeals said, funding for the Missouri Medicaid program, Mo Health Net, is appropriated annually by the General Assembly. The proposed measure does not direct or restrict the General Assembly's ability to change the amount of appropriations for the Mo Health Net program, or to increase or decrease funding for the program based on healthcare-related costs. In other words, the Court of Appeals says, we read this initiative as establishing eligibility, but leaving the legislature its traditional discretion over funding. And that was the construction that was necessary to come to the conclusion that it was not an illicit appropriation by initiative. Because they go on in the very next sentence to say, this interpretation harmonizes the provisions of the proposed measure, that's Amendment 2, and Article 3, Section 51, instead of creating an irreconcilable conflict. So the natural way forward is the way forward that the state proposes here, which harmonizes Article 3, Section 51 with Article 4, Section 36C, which is a very important provision because it takes that first step. It creates eligibility. It doesn't go the next step to appropriate money or to mandate appropriations because it can't do that under Article 3, Section 51. But creating eligibility is a very significant deal. That's the first step of the two-step process towards essentially legal authority, lawful authority to administer services to this population. So it's a significant provision, but it doesn't mandate that the legislature appropriate. And then that harmonizes both of those with House Bill 10 and House Bill 11, what the legislature that manifestly did in those two appropriations bills, which it had the constitutional authority to do, which was to appropriate money only for the pre-expansion population and not for the expansion population. So for all those reasons, Your Honor, and as to their count 2, I think they can see that count 2 kind of piggybacks on count 1 because it depends on whether or not there's appropriation authority in the first place. So I think both counts really turn on the argument that has just been presented. For all those reasons, Your Honor, we believe that the court ought to enter judgment in favor of defendants on both counts in the petition. Thank you.
Your Honor, I've had the privilege of arguing cases with Mr. Sauer before. I try to keep up, so I think I've got all of these down. But I did want to sort of start at the end and then maybe see if I can summarize our position on many of the things that he said. So in the Planned Parenthood case on page 210, the Supreme Court discusses this argument that you just heard from the state. They talk about the fact that the eligibility laws do not require funding. The constitutional amendment that we've been talking about did not require funding, nor do the statutes require funding. So there's a paragraph that begins finally. It's right, I believe that's, I was going to say it was a head note, but it's not. There's a paragraph that begins finally on that page. It says, finally, Mo Health Net argues that, in that case, Sections 2A, the substantive law, do not purport to fund Planned Parenthood. Same argument you just heard. The Constitution doesn't purport to fund what is being referred to as the expansion population. We'll get to that in a minute. Or any other authorized participation in delivery of goods services, nor do those statutes obligate the General Assembly to provide such funding in any given year. Fine. The Supreme Court says these assertions are far from the point. Exactly. Nothing in the law purports to appropriate money or to require an appropriation. Nothing mandates an appropriation be made. I'm paraphrasing here. It's beyond question that the General Assembly has the discretion to decide appropriations, but these bedrock legal principles do not resolve the present case. Here, in the Planned Parenthood case, the General Assembly chose to appropriate nearly $400 million for, among other things, providing physician services and family planning. Skipping a little, this was one of thousands of difficult decisions made each year in the appropriations process. But having made this decision, Mo Health Net is bound by the general law, Sections 208, 153, 208, 152, defining what those services are, and in that case, which providers are entitled to payment. Any attempt to use an appropriations bill to amend such general laws necessarily runs afoul of the multiple subject prohibition in Article 3, Section 23 of the Missouri Constitution. So let's bring that down. We showed you the appropriations for, let's talk about pharmacy. Missouri law talks about pharmacy services. There's nothing that says that stands appropriated. The General Assembly could, although it'd be a bad move, decide they don't want to fund pharmacy next year under state law. Now, the federal government might have a problem with that. But under state law, they could certainly decide, we don't want to fund the pharmacy program next year. That $1 billion we just looked at, not going to put it in. They have that right. But the Supreme Court has said, and it's consistent with all of the case law, that once they decide to fund the pharmacy program, they have to follow the general law on eligibility. And that means that everyone who is eligible to receive Medicaid is entitled to those services with that funding. Have they provided enough funding? I don't know. They rarely do. But whatever has been provided is going to have to be used for everyone who is eligible. I think that's a summary of the law in this area, and I think that's the case, and we've showed it. We've showed you the language there in the appropriations bill that the legislature did make the choice to fund those programs. Therefore, our clients are eligible. So I wanted to just briefly go through a few of the things Mr. Sauer brought up. I do think that, Your Honor can decide it's a little extra textual. I'm afraid, on some of these arguments, John's going to have to forfeit his Federalist Society membership card if we're not careful here. Because to know that the General Assembly did not fund, according to Mr. Sauer, what the governor requested, we have to look outside the bill at what the governor requested. To know that the legislature chose to fund at 60-40 when FMAP says that this particular population may be eligible for 90-10, we're going to have to look outside the bill. So these are extra textual arguments. We've also looked at failed bills, and the Missouri Supreme Court, as we mentioned in our briefing, has told us that failed bills are not good indicators of intent. And he also says everyone thought that they had not funded the expansion population. By the way, that's wrong. I mentioned to you in my opening. Senator Rowden, the majority leader in the Senate, Exhibit 20, said there may not be, I'm quoting here from Kurt Erickson's article in the Post-Dispatch, which is in evidence. Senator Rowden said there may not be enough money in state coffers to pay for an entire fiscal year of expansion, but it won't stop expansion from moving forward. Quote, my perspective has always been that at the end of the day, if the governor doesn't freeze enrollment of the population when they are eligible, then there is money in the budget for these folks to enroll. The majority leader said what I'm telling you, which is there is money in the budget for these folks to enroll. It may not be enough. That's a decision the legislature can make. They regularly underfund Medicaid and come back with supplementals, and they should do that. So I want to just run through a couple of things that Mr. Sauer said. He opened by talking about that it was clear from various indicators that the legislature was, quote, just funding the pre-expansion population. There is no pre-expansion population or expansion population. There's only eligible Medicaid members. That's the law. It's in the Constitution. And the legislature can't ignore that. In talking about that, he mentions that the eligibility criteria are never referred to, what he calls the expanded population, are never referred to in the appropriations bills. It doesn't say, here's some money for these people in the Constitution. It just occurred to me as he was saying that, if that's true, then nobody's eligible for Medicaid, because there's no reference to any eligibility criteria in any of these appropriation bills. So if we've got to have a specific appropriation that says, the poor and aged are eligible for nursing home Medicaid, it's not in there. That argument cannot be right. There is no reference to eligibility. For good reason, that's the law. So he gave you the example of an individual at DSS looking at the funding. I think it's pretty clear that they didn't get what they asked for. That's not the point. It happens all the time. They funded it a 60-40 match versus a 90-10. They could fund it a 50-50 match. They could fund it a 98-2 match. Now, the feds aren't going to give them that, but the General Assembly could make those decisions. It doesn't change the plain language of the appropriations bills that says that the appropriation is for coverage. Now, I did want to talk about more specifically Section 11.760, which was in the state's brief and is also something that you just heard about. And so this is the only, I believe, the only textual reference we've got from the state where they say, look at this section of the appropriation bill for the proposition that it somehow excludes folks who are eligible under the Missouri Constitution. Here's what it says. For payment to comprehensive prepaid health care plans as provided by federal or state law, or, okay, so for payments to comprehensive prepaid health care plans as provided by federal or state law, and surely we agree that the Constitution is state law and that the Constitution says that our clients shall receive coverage. Then there's an or. And then, Your Honor knows Medicaid probably as well as any judge, there's a whole lot of stuff. And there's various populations that are discussed there. There's a discussion about a particular rate cell within Medicaid and how you're going to develop that. I'm not going to, Mr. Ferber could probably explain all of that to you. But I'm just going to tell you that that or is pretty important and that the rest of it does not in any way negate the eligibility for those folks to participate in the prepaid plans. Now, real briefly, Mr. Sauer mentioned that you need to look at House Bill 5. There's an appropriation over there for technology. My plaintiffs don't care whether they get enrolled by a computer, by telemedicine, by artificial intelligence. You could take a piece of paper for all we care and have them fill that out and hand it in, okay? They're entitled to be enrolled. And Mr. Sauer said that the way he reads Planned Parenthood, we have to have a direct conflict in order for Planned Parenthood to apply. You've just heard from the state that my clients are not entitled to Medicaid coverage. They're not entitled to these services because of language in an appropriations bill, or more accurately, the lack of language in an appropriations bill. But the Constitution specifically says that they are entitled to coverage for these services. It is a direct conflict. And so what we've done in our position, in our briefing, is explain the route to how to interpret what the legislature has done as being perfectly constitutional. I think it was perfectly constitutional. It does not conflict because we have an eligible population that has funding for the services they're entitled to, and that's there is no conflict between those two. The population is funded. Thank you.
May I make 2 points, Your Honor? Just one. I just want to, I can't say it better, Your Honor, on this constitutional issue than was stated in the intervener's brief to the Western District Court of Appeals in Katie against Ashcroft, authored by Mr. Hatfield and Mr. Pearson. The court, quote, is duty-bound to interpret the initiative, Amendment 2, in a manner that harmonizes it with existing constitutional provisions and limitations on the initiative process. That's Article 3, Section 51's prohibition on appropriation by initiative. When the initiative is read in this manner, it does not appropriate funds by practical necessity or otherwise. The initiative merely expands eligibility for Medicaid benefits, leaving decisions about how to fund the program to the legislature. That's page 11 of their brief in Katie against Ashcroft. It's exactly right, but it's just the opposite of what's being argued in this case. It was much more persuasive when they said it last summer, and that was the state's position in this case. And that, I think, explains Mr. Hatfield's reliance on this Planned Parenthood decision. If you actually look to that finally paragraph that he cited in Planned Parenthood, that he's basically saying that in this case, Article 4, Section 36C plays the same role that Sections 208.152 and 153 play in the Planned Parenthood decision. But that language says, plainly, nothing in Sections 208.152 and 153, substitute in Amendment 2. Plainly, nothing in Amendment 2, Article 4, Section 36C, purports to appropriate money or to require an appropriation of any amount in any year, unless the funds stand appropriated in the Constitution. And that language, stand appropriated, is not in Article 4, Section 36C. So this language directly supports the state's position here. It doesn't support the argument that Mr. Hatfield is making. Again, they go on to say, here the General Assembly chose to appropriate. In other words, in that case, they did provide the money. They made the appropriation. Then they said, you can't exclude just one provider and not another provider when the statute says all eligible providers are entitled to reimbursement for services. Here we have a totally different thing. The whole statutory argument that we're fighting about is whether they did appropriate in the first place. We say they could not be constitutionally obligated to appropriate in the first place by Article 4, Section 36C, because it only addresses eligibility. And if you look at the actual bills, they didn't do that. And for that reason, we ask the court to enter a judgment in favor of the defendants on both counts.
Let's go back to Katie,
Yes, sir.
and I'll hear from both sides on that. It looks like everyone is pretty much in agreement that Katie said, if you interpret this way, that the bill does not require appropriation, then the constitutional amendment is valid and would have the same effect as the statute. Katie didn't say this, but would have the same effect as an amendment to 208-152 in terms of defining the eligible population.
Right.
Okay, and you guys aren't backing up on that?
No, not at all.
Okay, and the state's not backing up on that?
I believe that accurately states our position.
Okay, so that question of whether or not the whole thing is invalid based upon appropriation or a lack of substantial funding source, that's past us. And the best I could tell from this morning, Supreme Court denied transfer on it, and so Katie would be the law. Okay. All right, Mr. Hatfield, you said several times the legislature wants to change the eligibility requirements for Medicaid. They can do it. There's a couple of ways. They can amend the statutes. You think they can amend the statutes now?
Well, I meant that they could amend the statutes for what Mr. Sauer refers to as the pre-expansion population. So.
But they couldn't amend the statutes to say.
Oh, no, that'd be unconstitutional.
Okay.
Right.
So really what the choice is a constitutional amendment.
Well, I think that's fair.
Okay.
Yes, if they want to address this population.
Okay. Any thoughts on that, Mr. Sauer?
Nothing to add, Your Honor, unless you have questions.
Okay. Now, when you talk about a reasonable reader, okay, and I've looked at FUST, okay, FUST was whether or not certain persons sustained certain damages. I mean, that's a long way from knowing what the Fed-state match is, and doesn't that require you to know substantive facts outside the record?
That's correct, Your Honor. I think I like that phrase from FUST, reasonable reader, because I think it encapsulated a lot of the other cases that we cited that talk about considering the context and circumstances and having awareness of kind of background issues here. In other words, it's not reasonable to say, well, let me pick up this bill knowing literally nothing about Medicaid, which is kind of what the plaintiffs are arguing, and say, does this fund Medicaid expansion? A reasonable reader is informed. They understand what the federal matching rate is. They understand what the Medicaid program is and so forth. And that reasonable reader looks through and sees all these indications that Medicaid expansion wasn't fun.
You think that's the reasonable reader FUST talks about?
Well, I think that's the reasonable reader that FUST talks about, and the whole line of cases we cited that talk about considering the history and the context of the circumstances in the legislation. So that's different from extrinsic meaning with like floor statements of legislators. That's, relevant background knowledge about the problem that the legislature is addressing, and we got tons of cases that say you can look at that.
So, if I understand the plaintiff's position right, stand back for a second. Historically, we've underfunded Medicaid. We've had to come back for a supplemental.
Yes.
Okay? Do I understand your position to be is we've funded Medicaid. It's probably not going to be enough money. And so the point we reach when we've spent all the money initially appropriated is probably going to be a lot sooner with the population being expanded, more people requiring more services.
Right.
But it is the same situation is that the appropriation is insufficient for the services to be used by the eligible population.
Well, we think so, right? I mean, as we do every year.
Sure.
We don't know exactly what, whether we're going to run out of money, how many people are going to enroll, what the spend is going to be, et cetera. This, as we discussed in Katie, the population that was added in the constitutional amendment may not end up being that expensive. So these are, and I am answering Your Honor's question. I agree with the Supreme Court. These are all difficult decisions the legislature has to make every day. That's up to them. We may have an underfunded program that will require a supplemental. You're
But that's no different than we have right now with the
FRA.
pre-existing expansion or pre-expansion population.
The difference is the amount it's underfunded is exactly the amount that was requested for the expansion population. So that supports the inference. So you're reading these texts, say what's going on here, that supports the inference that they're appropriating money just for the pre-expansion population.
And you know, where do I get that inference without knowing all these other things?
I think the only fact you would need to know to look at that would be the numbers in the bills, which is the amount appropriated, and compare that to the budget requests for Medicaid expansion.
But, and I've been through this before, and I've got mixed results out of the Court of Appeals on this, but, you know, the budget requests, they're not in HB 11.
I believe they'd be what the Court of Appeals and the Supreme Court have referred to as context and circumstances. I mean, that's a pretty powerful indicator.
How far does that go?
I don't think we need to go beyond the budget request in this particular case, Judge. And again, that's one of several points we made about the meaning of these bills. You don't even need to get to that. All you need to do is look at a federal regulation to know what the FMATCH matching percentage is. You can walk through every single one of the line items and see it appropriating money at 2/3, 1/3. It's just.
But I would have to go to the federal regs.
Yeah, and that's perfectly legitimate. I don't think Mr. Hatfield disputes that that's a legitimate form of interpretation to interpret a state statutory provision in light of a federal statutory provision on a related topic that directly intersects. Surely he doesn't contend that.
It would look like there is virtually nothing at the point of Katie. Well, so first you have Katie, and then there's the election and the certification of the election. It would appear then from the plaintiff's position is, unless you chose not to fund Medicaid, which is an option I guess the state would have, if they were going to fund Medicaid, your position would be is there's nothing they can do. If they're going to fund Medicaid, they're going to fund this eligible population.
Yes, that's right. Sorry, at the end there, you saved it all for me. If they're going to fund Medicaid, this population has to be included. There are, of course, things they could do to save money. So they could go change 208, they could go change services for the entire population, but they can't rewrite the constitutional provision and say, here's money for physician services for these people, but not for these new people. If you're going to fund what you said, if you're going to fund Medicaid, it now includes the population that is specified in the Constitution.
And just a follow-up point on that, Your Honor suggested there is the option of not funding Medicaid. As Mr. Hatfield, I think, conceded earlier in his argument, that would create problems under federal law and with CMS. They don't really have the option of not funding Medicaid at all. And therefore, it's a practical necessity under the Supreme Court's opinion in Chastain. On his theory, his view is if you put any funds in at all, you have to fund the expansion population. That means that Article 4, Section 36C mandates an appropriation by practical necessity. So it's a poison pill. Their argument is self-defeating. If that's true, it didn't get validly enacted in the first place. Can't be right.
All right, I think that's the questions that I have. I don't remember if I made a docket entry, but I know I sent an email when we were trying to reschedule this that the parties were requested to prepare me a proposed judgment and something that I can edit.
So did you want to email?
Yeah, Judge, why don't I'll give you our flash drive, and then I have mine loaded up. I'll just power my phone, and I'll email it. So Mr. Hatfield's getting this thing that you just got. I'll email it around to you guys, and we can do it vice versa.
All right.
Your Honor, do you want exhibits? They're all in case.
I've got them all electronically, so I can find them that way.
Yeah, you have them all if you want a paper copy.
No, I've looked at them electronically, so I would prefer to do that. It would be another, 27 binders in my office. All right. All right, I think that concludes the hearing for today. Should the cause submitted taken under advisement. I am sensitive to the time. We did lose a couple of days here with this, and so it'll be my goal then to get you something out here the next day or so. It's probably Wednesday. Just looking at what we have previously scheduled. scheduled here in the court. So thank everybody for your time and the briefing, and we'll be in recess.
Thank you, Judge.
Thanks.
Hey, I really appreciate you guys helping out and working really well. I think you're right. The stipulated facts is a good thing. So, great work.